ಎಲ್ಲರಿಗೂ ನಮಸ್ಕಾರ. ಕರ್ನಾಟಕ ರಾಜ್ಯ ವಕೀಲರ ಪರಿಷತ್ತು ಹಾಗೂ KSBC ಲಾ ಅಕಾಡೆಮಿ ಇವರು ನಡೆಸಿಕೊಡುತ್ತಿರುವ ಬೆಳಕು ಉಪನ್ಯಾಸ ಕಾರ್ಯಕ್ರಮಕ್ಕೆ ತಮ್ಮೆಲ್ಲರಿಗೂ ಹೃತ್ಪೂರ್ವಕವಾದಂತಹ ಸ್ವಾಗತವನ್ನು ಬಯಸ್ತಾ ಇದ್ದೇನೆ. ನನ್ನ ಜೊತೆಗೆ ಕರ್ನಾಟಕ ರಾಜ್ಯ ಬಾರ್ ಕೌನ್ಸಿಲ್ ಸದಸ್ಯರು ಮತ್ತು KSBC ಲಾ ಅಕಾಡೆಮಿ ಅಧ್ಯಕ್ಷರಾದ ಶ್ರೀ ಗೌತಮ್ ಚಂದ್ ಅವರಿದ್ದಾರೆ. ಇಂದಿನ ಉಪನ್ಯಾಸಕಾರರು ಶ್ರೀ ಮೂರ್ತಿ ನಾಯಕ್, ಸೀನಿಯರ್ ಅಡ್ವೊಕೇಟ್, ಹೈಕೋರ್ಟ್ ಆಫ್ ಕರ್ನಾಟಕ. Today's lecture is dedicated to one of the noble advocate from Karnataka, Sri Basavaraj Guru Basavaraj Naik, popularly known as Sri B.G. Naik. Sri B.G. Naik was born on 23rd September 1926 in a remote village called Naganur, Bailahongla Taluk, Belagavi district. He got himself educated in Belagavi. He completed his law degree in RLS Law College, Belagavi. After completion of law, he started his practice as a pleader in Belagavi till the year 1968. In the year 1968, he shifted his practice to Bengaluru in the High Court of Karnataka. He mainly practiced on criminal appellate jurisdiction till the year 2011. And after his practice, he lived his retired life for about 5 years and lived happily with his children. He breathed his last on 9/5/2016. Dear friends, the institution of judiciary has been built brick by brick by some of the noblest advocates with the strong determination, unquestionable integrity, and hard work. I am proud to say that Sri B.G. Naik was one of them. I was lucky enough to watch his arguments in the High Court of Karnataka, and he was the way the presentation, the mannerisms, and the temperament was unbeatable. So it's a matter of pride for the Karnataka State Bar Council and also the KSBC Law Academy to dedicate today's lecture to Sri Basavaraj Guru Basavaraj Naik. So I request Sri Murthy Naik to take over the seminar and give the lecture on today's topic. Thank you very much. Over to you, Sri Naik, sir.
Yeah, thank you. Good evening, ladies and gentlemen. At the outset, I must congratulate the Karnataka State Bar Council and the Law Academy for starting this lecture series in memory of leading advocates across the state. This is mainly the brainchild of Mr. Basavaraj and Mr. Gautam Chand. And in fact, I deem it a great privilege and honor to deliver the lecture today, which is dedicated to Sri B.G. Naik, a leading lawyer on the criminal side, though I did not get an opportunity to witness his arguments because by the time I joined the bar, he had stopped practicing, but I have met him a number of times when I had gone to brief Sri Ravi Naik. I have heard that he was very adept in procedures and was very disciplined and methodical in his submissions and used to make copious notes and would come to the court at sharp 10 o'clock and would be sitting on the first chair. And he had that authority and he was considered to be the doyen of the criminal bar. And in fact, today's topic is befitting and was chosen because he was a lawyer who was practicing mainly on the criminal side, predominantly on the criminal side. I think Mr. Basavaraj missed one aspect. He was also the member of the Bar Council, if I'm not wrong. He was elected member of the Bar Council. And he also represented the Karnataka State Bar Council in the Bar Council of India. Those were the times when all stalwarts used to be members of the Bar Council, like Mr. Ramjit Malani and all. So in those days, Bar Council was represented by true practicing lawyers. And anyway, be that as it may, now let us delve into today's topic, that is criminal trials in India, past and present. Friends, it assumes importance because around a month back, the new procedure code, the new procedure laws has come into force. That is known as the BNSS. So it replaces the CRPC of 1973. Prior to 1973, there was the 1898 code, that is the CRPC of 1898. And for a very long time, we were governed, and prior to that, we probably had the 1890 code. But 1898 code was replaced with the 1973 code. So for 75 years, the 1898 code governed the law on procedure as far as criminal jurisprudence in India is concerned. And in fact, we are now left with very few lawyers in the state and also in the country who would have practiced when the 1898 code was in subsistence. And Shri B.G. Naik was one of them because they had all started their practice in the early 1950s. Hence, the today's topic assumes greater importance. As all of you all are aware, the 1898 code had a slightly different mechanism in terms of criminal trials because in the 1973 code you didn't have the procedure of pre-committal inquiry, whereas in the 1898 code you had the procedure in inquiries, which was known as procedure in inquiries preparatory to committal. And that was section 207 capital A. And as per that provision, the magistrate was required to conduct an inquiry. In the sense, he had to in fact, record evidence, and if found fit, if it was found that there was enough evidence, prima facie material for committal, only then it was committed to the sessions court. So this was how the 1898 code was structured. Then, of course, I would not delve deeper into that aspect. Then came the 1973 code. 1973 code has been divided into several chapters, and out of which 5 chapters are dedicated to the various trial procedures, like trial before sessions court, then trial before magistrate, that is known as the warrant case, trial of warrant cases upon a police report. Then there is another subdivision in that chapter, that is trial of warrant cases otherwise on police report. Then you have summary summons trials and summary trials. So these are the 5 predominant chapters pertaining to trial of criminal cases in India. This has the, as I told you earlier, now the 73 code is replaced with the Nagarik Suraksha BNSS, Bharatiya Nagarik Suraksha Samhita 2023, which has come into effect from 1st of July. And as per the said enactment, or rather the said enactment also contains 5 kind of trials. There isn't much change. Only thing is there is a cosmetic change as far as the chapters are concerned. Just for ready reference of the viewers, I will quickly refer to the chapters. In the CRPC of 1973, Chapter 18 dealt with sessions trial, whereas in the BNSS it has become Chapter 19. And then Chapter 19 of CRPC, that is trial of warrant cases by magistrate, has become 20. And cases instituted on police report, otherwise on police report, etc. Then you have Chapter 20, that is trial of summons cases in CRPC. That has become Chapter 21 in BNSS. And summary trial, that is Chapter 22. So we will deal with the sessions trial first. In fact, it is so structured that the 5 trials, it commences with the most serious one, that is the sessions trial. Then comes the trial of warrant cases by magistrate. Now, as far as sessions trial is concerned, a sessions court gets jurisdiction upon committal by the magistrate. Unlike the 1898 code, there isn't any pre-committal inquiry to be conducted as per the 1973 code nor the new BNSS. So in fact, direct cognizance by the sessions court is barred unless a statute specifically provides for example, PC Act or PMLA provides for cognizance by the special court, who is the sessions judge. So that being the case, direct cognizance is barred under section 193 of CRPC. And trial is to be conducted by the public prosecutor, etc. As far as a sessions trial is concerned, we have the concept of opening case of prosecution, which found place in 226 of CRPC, and that has been incorporated in the BNSS also. I will not refer to the sections to avoid confusion. I will only refer to the provision as a whole. So this opening case of prosecution is a very important stage where the public prosecutor has to place his case, or rather the case of the prosecution, before the court, and he has to very briefly and succinctly touch upon the evidence collected, that is the material collected during the course of investigation, and on what basis he proposes to proceed further. And the very word opening case of prosecution would signify that this is not an idle formality, and the public prosecutor will have to satisfy the court that there is sufficient material warranting framing of charge. And this is a very a brief procedure, but a very important step in a sessions trial. After this comes the stage of discharge. Stage of discharge, normally in the sessions under CRPC, it was 227. Stage of discharge, the sessions judge will hear both the prosecutor as well as the counsel for the accused, and consider the materials produced along with the charge sheet, that is the police report, and will take a decision whether to discharge the accused or to proceed further by framing charge. In fact, at that stage also, if he decides to frame charge, he can frame charge, but he comes to a conclusion that no case is made out for framing a charge which is triable by the Court of Session, then he can frame charge and resend it back to the magistrate. For example, in a case of assault, the prosecution has filed a charge sheet for offence under 307. After hearing the prosecutor as well as the defense, if the learned sessions judge comes to a conclusion that only an offence under section 326 or for that matter 325 or 324 is made out, which is triable by a court of session, then he can frame charge and send it back to the learned magistrate, because those are offences triable by the court of by the JMFCs. So there are various checks and balances in the code as well as the new BNSS. It's a robust procedure and a very important procedure in a criminal trial, because this is the starting point. Friends, unlike a civil trial, for example, a civil suit, there are various steps or various procedures provided in the CPC in particular and other enactments also, where a civil case can be nipped in the bud. For example, rejection of plaint or return of plaint. Starts with return of plaint, then rejection of plaint, then framing of preliminary issue, so many things. And if there are admissions, judgment based on admissions, etc. When compared to the civil procedure code, the scope for nipping a criminal trial at the nascent stage is very less. Either the accused who has been summoned and who has been arraigned as an accused can approach the higher court, that is the High Court in case of a sessions case, by challenging the very charge sheet or the order of cognizance, the criminal proceedings, etc. So framing of charge is a very important stage as far as a sessions trial is concerned. Hence, the Supreme Court has time and again, and also our High Court has emphasized that framing of charge is not an idle formality. The sessions judge has to sift and weigh the materials produced by the prosecution. By sift and weigh, they mean it is virtually like churning the grain from the chaff, that is separating the grain from the chaff, which is ordinarily known as. So sifting is going through, scanning through the documents produced by the prosecution, but not like a mini trial. That is the test. You have to scan through. So that is the significance behind opening case of prosecution. In those days, in fact, my father used to regularly mention, because even he had started prior to 1970, that is in 50s, late Shri B.G. Naik and my father all had started their practice and in the trial court. So their foundation was very robust. They had a solid foundation because they practiced on the trial side. They knew the procedures threadbare. And that is why judges also used to respect them, because they were so confident, and the confidence came from the knowledge they had, knowledge they possessed. It was not some superficial knowledge. It is not some cut and paste or some Google knowledge like some youngsters like me try to adopt. They were all robust knowledge, and in those days, it was very tough. There was no access to internet, etc. In the sense, internet was unheard of. So they had to refer to commentaries, etc., and which were also very scarce. So the procedure of opening case of prosecution, which is only provided in a sessions trial, in the sessions trial procedure is for the purpose, because sessions case, as I told you all earlier, pertains to serious offences like murder, rape, dacoity, and kidnapping for ransom, etc. Not all and sundry offences are tried by the sessions judges. So that being the case, before putting the accused on trial, the lawmakers had thought it fit to entrust this power of going through, of scanning through the materials and hearing the prosecutor and objectively and subjectively satisfying himself or herself that there is some substance in the allegations made by the prosecution. Because unlike 207A of the 1898 code, where the magistrate was entrusted with that power of committee of conducting this pre-committal inquiry. But for some reason that was discontinued in the 1973 code. Probably they thought that it was not conducive. Hence, the sessions judge himself was entrusted with the task of hearing. Hence, the law on this point is fairly well settled. In fact, the prominent judgment on this issue of framing of charge is L. Muniswamy versus State of Karnataka, which arose from our High Court, where the Honorable Supreme Court has very copiously and exhaustively dealt with the law, or rather laid down the law, because it was at the nascent stage in the year 1977. Immediately after the 1973 code was enacted. So this L. Muniswamy versus State of Karnataka was in, and coincidentally was argued by Shri B.G. Naik in the Karnataka High Court. So this went to the Supreme Court, and the Supreme Court laid down the law and held that it is the bounden duty of the sessions judge to sift and weigh and to see whether there is any substance in the allegation made by the prosecution, and it had the test that was laid down in Muniswamy's case was if mere suspicion will not warrant framing of charge. For framing a charge, there has to be grave suspicion. So this is the test. And another disclaimer was it can't be treated as a mini trial. A mini trial cannot be conducted. So this was in the form of a safeguard, because there was no occasion for recording evidence as far as a sessions trial is concerned. So that being the case, Muniswamy's judgment still holds the field even after nearly 46 years. It still holds the field and is like a Bhagavad Gita as far as the law of discharge is concerned. Then you have many cases, that is century spinning, that is 1972, as far as the earlier code is concerned. Then so many other cases. Then you have Praful Kumar Samal, etc., etc. They go on. Then in 2005, that is in Devendranath Padi's case, the larger bench of the Supreme Court, consisting of 3 judges, considered the point as to whether at the stage of framing of charge, can the accused produce any material that will support him to get out of the radar and will be able to convince the court that he is innocent. In the earlier judgment, the 2 judges bench of Satish Mehra, in the case of Satish Mehra versus Delhi administration, that is 1996, 9 SEC 766, Supreme Court had held that yes, an accused can produce some material that can absolve him from the prosecution. But the larger bench in Debendranath Padi's case, for the benefit of viewers, especially the younger members of the bar, I would give the citation, that is 2005 1 SEC 568. Supreme Court held no, you can't do that, but you can produce those documents of unimpeachable character of sterling quality, and that was again the nomenclature or the test that was coined by the Supreme Court as far as what kind of documents can be produced even before the High Court while seeking quashing of the proceedings, criminal proceedings under 482 or in exercise of its writ jurisdiction under 226. So while dealing with this aspect, the Supreme Court held that before the Sessions Court, you cannot produce such a document, even if it is of an unimpeachable character of sterling quality, but that has to be produced, that can be produced before the High Court to convince the court that the accused petitioner is innocent. So that is the law. Then that has traveled over the period of time. And in fact, as I said earlier, Muniswami's case still holds the field. And the Honorable Supreme Court, around 2 weeks back, in the case of Ram Prakash Chadda versus State of UP, 2024, SCC Online SC 1709 has again reiterated the law that was laid down in Muniswami's case and which was reiterated. And in fact, it says that the court concerned is bound to disclose the reason, though not in detail, for finding sufficient ground for rejecting the application, or in other words, for finding prima facie case, as it will enable the Superior Court to examine the challenge against the order of rejection. So broadly, this is the law as far as discharge is concerned before a Sessions Court. Then you have the regular procedure of trial, etc. Then acquitting an accused under 232, etc. I will not delve much on the procedure aspect, but I will only touch upon those aspects which we as counsels deal with on a day-to-day basis. So discharge and framing of charge, etc. is a very important stage. Hence, as far as Sessions trial is concerned, this is a very important phase. Then comes trial of warrant cases by magistrate. This is 238 and 230. This starts at 238 in the CRPC of 1973. So that has now become 261 to 266. Friends, before I deal with a warrant case and a summons case, that is the trial procedure of warrant case and summons case, it's very important to know, especially for the younger members of the bar, that a summons case is, or rather, I'll put it this way, a warrant case is something which carries a sentence of more than 2 years or imprisonment for life or death. So any offense carrying a sentence of more than 2 years or imprisonment for life or death is a warrant case. Any other offense other than having a lesser sentence, lesser than 2 years, is a summons case. It is as simple as that. So in a warrant case, you have two parts. That is warrant case upon a police report, that is upon a charge sheet, and warrant case otherwise on a police report, that is upon a complaint, which in normal common parlance is known as private complaint. The first part, that is A and B, in the 1973 court, it was divided into A and B. That was chapter 19. If you would see again, the flow of section or the arrangement of section is similar to that of a sessions trial procedure only. The fine distinction is, while especially as far as discharge is concerned, in a 227, the word employed is slightly different, whereas in a warrant procedure, the word employed in 239 is the charge has to, if the magistrate comes to a conclusion that the allegation is groundless or the charge is groundless, then he shall discharge. Whereas in 227, the sessions judge has to come to a conclusion that there is no sufficient ground for proceeding against the accused. This is a very fine distinction. So 238, of course, deals with compliance of section 207, that is the all the requirements of 207, furnishing the copies, etc. As far as 239 is concerned, this is similar, but the only distinguishing feature and which is not used is, in fact, in a couple of matters I have argued this. There is only one judgment of our High Court, that is in the case of J. Umadevi versus State, that is ILR 2013, where Justice Jawad Rahim has interpreted the word after giving an opportunity to the accused of being heard and examining him. Examination means the accused can step into the witness box and depose in support of his prayer for discharge. That is how the section is. That is the difference between 227 and 239. Whereas in a 227 procedure, when you argue for discharge, you cannot plead any evidence. And this argument of mine gets reinforced with the new BNSs. BNSs, in fact, clearly says, the corresponding section of BNSs says that the examination can be conducted either through electronic means or through other means. If you could quickly glance through the new section of BNSs, which is corresponding to 239, is 262.2. And if you could quickly scan through 262.2, this says that if upon considering the police report and the documents sent with it under section 193 and making such examination, if any, this is very important, of the accused, either physically or through audio, video, electronic means, as the magistrate thinks necessary and after giving the prosecution and the accused sufficient opportunity. So this makes it amply clear, because I had argued it in at least half a dozen cases, and the Honorable High Court was not pleased to accept my argument that examination of accused doesn't mean or doesn't give a right to the accused to examine in support of his innocence. But now 262.2 of the BNSS makes it very clear that examination means examination of the accused, meaning thereby the accused can get into the witness box and he can depose. Having said that, it is not in the nature of an accused statement under 313, because accused statement is between the court and the accused. Here the accused can depose, can summarize on what grounds he is seeking his discharge. So that is the whole object of 262.2 of BNSS. And the new feature as far as the 73 code and the present BNSS is a prayer or a claim for discharge has to be filed within 60 days after the magistrate is satisfied that there is compliance of section 230. Section 230 is pari materia to the old 207, that is compliance of all the procedures, etc. So within 60 days, a prayer for discharge or a claim for discharge should be made by the accused is what the new BNSS mandates. So if this is almost akin to the filing of written statement within 90 days. So they have probably to save time because there was no outer limit. In fact, I feel this was needed. Otherwise, in a case where there are several accused, say around 25 accused 20 will file an application for discharge on one day and accused number 14 will file it after 1 year. So it was causing a lot of hardship to all the accused. So this outer limit of 60 days introduced in both as far as sessions trial and warrant case was the need of the hour according to me, and that has been rightly included. Now the procedure as far as warrant case is verbatim the same. BNSS and CRPC of the 1973, they are verbatim the same. The inframing of charge, etc. Only the sections have changed. Then part B of this trial of warrant cases is in respect of cases instituted, otherwise they are not police report. Friends, there are certain cases where the statute mandates that a complaint only has to be filed. For example, the MMDR Act mandates that only a complaint can be filed. There cannot be a police report, there cannot be an investigation. If I am not wrong, it is section 22 of the MMDR Act. Likewise, you have so many other statutes like the Air Pollution Act, Water Act, etc., where the sentence is more than 2 years, then the procedure to be adopted when a complaint is filed would be as per Part B. So now in the BNSS, it commences from section 267. Earlier it was 244 of CRPC. Here, in this category of cases, the distinguishing or the special feature is that there is a stage for evidence for prosecution. Normally, it is known as EBC. The trial judges, the magistrates treat it as EBC, whereas in a sessions trial or a trial in a warrant case upon a police report, it's known as HBC, hearing before charge. This is known as EBC, that is evidence before charge. And here the prosecution has to lead evidence even before the charge is framed. Mere filing of a complaint would not suffice. They will have to file complaint, then lead evidence, then the magistrate will record evidence under 244, and then under 245 will decide whether to discharge the accused or to proceed further under 246. Now the provisions are verbatim the same, no change whatsoever in the BNSS. The only thing is it has become 268, 269, etc. The Honorable Supreme Court, in a notable judgment, held that even before the evidence of charge is before charge is recorded, the accused can, because no sooner the complaint is filed and cognizance is taken, sworn statement is recorded, then the inquiry under 202 is conducted and summons is issued, the accused appear. Then the accused can seek discharge. He need not wait till the formal evidence is led by the prosecution under 244. And in the case of Ajay Kumar Ghosh, that is 2009 14 SCC 115, the Supreme Court has held that he did not wait till the evidence is recorded. This has been reiterated in the case of Vishnu Kumar Shukla and another, that is 2023 SCC Online SC 1582. The Supreme Court has exhaustively and copiously considered all the earlier judgments. It has surveyed and it has reiterated that yes, the law laid down in Ajay Kumar Ghosh is sound and correct. And even before the evidence is laid, a claim for discharge can be staked by the accused, and he can. So the magistrate need not wait, and even at that stage, he can discharge the accused. Then going further, if the magistrate, after hearing the accused, considers that it warrants recording of the evidence, then he can record evidence under 244 and then decide under 245. So in this procedure, warrant case, otherwise upon a police report, in this procedure, there are two phases or two stages where the accused gets a right to pray for discharge. That is prior to 244 and after 244. If for some reason, after recording the evidence, if the prosecution, if the magistrate is of the opinion that a full-fledged trial is necessary, then the charge under 246 will be framed, and that is now 269 of the BNS. So this is how the procedure as far as warrant cases is structured. Then comes the summons case. Friends, trial of summons cases, that is chapter 20 in CRPC. Here it starts with 251. That normally a summons case is the offenses which are tried as summons cases are normally non-cognizable. But there are certain exceptional offenses like 304A. 304A, as it stood in the IPC, was punishable with a maximum sentence of 2 years, meaning thereby it has to be tried as a summons case, but it was a cognizable offense. So there are exceptions. Now, of course, in the new BNS, that is, which has replaced the IPC, 304A, the corresponding section is 106 of BNS. You have it is subdivided into several parts. This 304A, it says if it is driving rash or negligent driving, and if the driver doesn't stop, then the sentence extends up to 10 years. That is 106(2) of BNS. And if it is negligence by a medical practitioner, it is 2 years. And if it is normal negligence, it is 5 years. Earlier, this 304A did not have these bifurcations. It was one straitjacket which said rash, the death caused by rash and negligent act. But whereas now there is a bifurcation in the BNS. So no longer all the offences pertaining to rashness and negligence, or rashness or negligence, will no longer be tried as summons cases. So the test for trying an offence as a summons case or a warrant case is the only test is the sentence that a particular offence carries. If it is more than 2 years, then automatically it is warrant case. If it is less than 2 years, it becomes summons case. So in a summons trial procedure, there is no scope for discharge. Normally, these petty offences or anomaly offences such as the hurt, simple hurt, etc., where summons cases, that is, they did not have, for example, mischief, etc., they did not carry a sentence of more than 2 years. Hence, they were all tried as summons cases and did not provide for option of discharge. The plea was recorded under 251. The substance of the accusation was read out. Plea was recorded. Either the accused had to plead guilty or had to plead innocence and would be tried. Now, of course, in the new BNSS, the lawmakers have introduced a provision where it says that no sooner a complaint is presented, the accused has to be heard even before taking cognizance. Though the arrangement of section is slightly topsy-turvy, because this provision with regard to hearing to be afforded to the accused does not find place in the cognizance section, but it finds place in the chapter pertaining to issue of process, meaning thereby no cognizance can be taken straight away without affording an opportunity to the accused. So this is almost a safeguard to protect the accused from frivolous litigation, and especially in those cases where complaints are filed. And this would extend to the offences under the Negotiable Instruments Act also. As all of you all know, friends, the most of the magistrates court across the state and across the country is flooded with NI Act cases, and lot of time is consumed for disposal of these NI Act cases, which of course has to be tried as a summary case. So in such cases, this enactment, this mandate with regard to hearing the accused will be useful. As far as the summons trial procedure, the Supreme Court in a offbeat judgment had held that that is in the case of Bhushan Kumar had held that the accused can argue for discharge under 239, which was incorrect and which is rather per incurium, and rightly so in a later judgment in the case of Amit Sibal versus Arvind Kejriwal, that is 2018-12 SEC 165. It has been laid to rest and clarified that no, you can't argue for discharge in a summons case. What you have to do is you have to approach the higher court either by filing a revision to the sessions court if permissible, or revision to the high court, or a 482 or a writ petition. In fact, in another judgment in KM Matthews, that is 1992 1 SEC 217, the Supreme Court, while dealing with an offense of defamation, had held that after the summons is issued under 204 and after the accused enters appearance, he can seek for dismissal of the complaint under 203. This was doubted, and this held the field for nearly 12 years. But after 12 years, this was doubted by another coordinate bench, and hence it was referred to a larger bench comprising of 3 judges in the case of Adalat Prasad, that is 2004-7 SEC 338, and the larger bench held that there is no question of traveling back. Once 204 summons under 204 is issued, you cannot travel back and this an indirect way of seeking discharge. That is by filing an application under 203 is nothing but seeking discharge. So this also has been probably that's the reason why the lawmakers have thought it fit to introduce this provision of hearing the accused even before the cognizance is taken, so that they can nip in the bud the frivolous or complaints and offences. And that's a welcome move. And uh, in fact, in a number of cases, there were varied offbeat judgments of the Supreme Court. The Supreme Court in an NI Act case held that provision of 258, that is stoppage of proceedings, can be invoked to seek discharge, which is again wrong, because 258 deals with a final report. You can seek stoppage only in cases otherwise than on complaint. That is the wording. So that was corrected by the larger bench, and the larger bench clarified that no, you can't seek stoppage of proceeding. So all these ingenious, indirect methods of seeking discharge in a summons case is not permissible. And the Supreme Court, in fact, as far as NI Act offences are concerned, the Constitution bench in re pertaining to disposal of expeditious disposal of NI Act cases has which is reported in 2021 16 SCC 116 has laid down all the guidelines pertaining to the disposal of NI Act cases. And NI Act cases, friends, the statute itself mandates that it has to be tried as a summary case. That is what the mandate prescribes. But the Supreme Court says that it has to be scrupulously followed, and reasons will have to be given, will have to be mentioned in the order sheet if it has to be tried as a summons case. Of course, the procedure for a summary trial and a summons case more or less is the same, but especially with regard to NI Act cases, after the Indian Bank judgment, that is the 2014 Indian Bank judgment, summary procedure is introduced. That is, the sworn statement has to be recorded the same day when the complaint is filed, and the sworn statement is treated as the evidence for the complainant. Straight away, once the accused is summoned and he appears, he has the option of requesting the court to cross-examine him, or else it will be straight away posted for accused statement, and then it will be posted for the evidence on the side of the accused. So all these checks and balances have been time and again laid down by the Supreme Court, which has been followed by our High Court and the other High Courts. So this being the case, these are the 5 kinds of trials, friends, that is sessions trial, warrant trial upon a police report, warrant trial otherwise on a police report, summons trial, and a summary trial. So, in Adalat Prasad, in fact, the Supreme Court said you can't seek for dismissal, you will have to challenge the proceedings before the higher court by way of a 482 or by way of a revision. Now it is in fact well settled that, because there was some confusion with regard to whether an issuance of process or taking of cognizance is an interlocutory order or intermediate order, etc. So commencing with Madhulimaye, that has been well settled, wherein the Supreme Court has held that issuance of process or taking of cognizance is not an interlocutory order as envisaged under section 397(2) of CRPC. It's an intermediate order. Hence, amenable to revisional jurisdiction of the Sessions Court or the High Court. Then further, there was some confusion with regard to whether a framing of a charge or rejection of a prayer for discharge can be challenged by filing a revision petition. That also has been well settled now, because in Madhulimai and then VC Shukla, because VC Shukla's case was a case decided by the 4 judges of the Supreme Court. So there is some confusion. Now, in Asian resurfacing, that is 2018-16 SEC 299, the Supreme Court has held that a framing of charge or a rejection of a prayer for discharge is amenable to revisional jurisdiction or writ jurisdiction, or even a 482 can be filed. That is the present 438 of the BNSS. So, friends, this is a brief backdrop of the kinds of trial, and as a supplementary, as a supplement or as a bonus, I would in fact request all the younger members who have logged in and who would be viewing this later to read these 5 judgments. According to me, these 5 judgments are very important for any practitioner who practices on the trial side. Starting with 1952, Volume 2 SEC 392, that is Chellur Mankal Narayan Itti Ravi Nambudri versus State of Travancore Cochin. This has laid down the entire gamut, and this is the earliest judgment on the point, that is 1952. So, Chellur Mankal Narayan Itti Ravi Nambudri. So, this is on the point of criminal breach of trust. What amounts to criminal breach of trust, and etc. Then comes Vadivelu Thevar versus State of Madras, AIR 1957, Supreme Court 614. Friends, these judgments are followed even today. So, that being the case, this is on the point of the efficacy of evidence, reliable evidence, unreliable, wholly reliable, etc. So it makes a very interesting read, and this is even followed till date. As late as 2022, in the case of Khema alias Khem, it was followed. Then comes Anant Chintaman Lagu, that is AIR 1960, Supreme Court, page 500. This is a case of poisoning on the train by a doctor, that is the appellant, who poisoned his patient en route a railway journey. So, circumstantial evidence, and this is, if you juxtapose the facts of this case with the facts of Shraddhananda's case, that is Shakira Khalili's case, they are so identical. That is 2008 SEC. So these are a few important judgments. Then comes Sharad Birdi Chand Sharda versus State of Maharashtra on circumstantial evidence. That is 1984, 4 SEC 116. A very beautiful judgment. The entire scope of circumstantial evidence, how it has to be proved, what are the prerequisites, everything has been considered, and it is followed even till this date. And another judgment is 1996, 10 SEC 236, Divakar Nikant Hegde versus State of Karnataka. This arose from my district, my hometown. And in fact, my father had conducted the trial before the Sessions Court. This eventually, they were convicted before the trial court and partly confirmed in the High Court. And that was, it ended in an acquittal before the Supreme Court. So, according to me, these, to start with, youngsters should go through these judgments to have a brief overview of how the law, criminal jurisprudence in India has traveled, and and of course follow up, top it up with the latest judgments. Now, on a day-to-day basis, you get all the updates in live laws, SECs, etc. So this is an overview on today's topic. I once again thank the organizers, the KSBC Law Academy, for conducting this lecture, and it was indeed a privilege for me to deliver this lecture, which is dedicated to the memory of Sri BG Naik. Thank you.
That was a magnificent and high meticulous lecture, sir. Though ತಮಗೆ ಹುಷಾರಿಲ್ದಲ್ಲ ಇದ್ರೂ ಕೂಡ ತಾವು ಇಲ್ಲಿ ಆಗಮಿಸಿ ನಮಗೆ ಉಪನ್ಯಾಸವನ್ನು ನೀಡಿದ್ದೀರಿ. ಈಗ ಪ್ರಶ್ನೋತ್ತರ ಕಾರ್ಯಕ್ರಮ. ದಯವಿಟ್ಟು ತಮ್ಮ ಮೈಕನ್ನ ಅನ್ಮ್ಯೂಟ್ ಮಾಡಿಕೊಂಡು ತಮ್ಮ ಪ್ರಶ್ನೆಗಳನ್ನ ಮಾನ್ಯ ಉಪನ್ಯಾಸಕಾರರಿಗೆ ಕೇಳಬಹುದು. ಒಂದು ಕ್ವಶನ್ ಯಾರೋ ಕಳಿಸಿದ್ದಾರೆ, ಅಷ್ಟರೊಳಗಡೆ ತಾವು ಅನ್ಮ್ಯೂಟ್ ಮಾಡಿ ಕೇಳ್ಬೋದು. ಯಾರಾದ್ರೂ ಅನ್ಮ್ಯೂಟ್ ಮಾಡಂಗಿಲ್ಲ. ಸುಮಾರು ಪ್ರಶ್ನೆಗಳು ಬಂದಿದ್ದಾವೆ. ಒಂದು ನಿಮಿಷ. Accused obtained bail at crime stage. Court had put up after charge sheet this case. Now 60 days time to file discharge petition is over. When accused summons and appearance before the court. Adena gottaagtilla. Please clarify again the procedure to be followed by magistrate after filing of the complaint in section 138 case under BNSS Act.
Yes, under the BNSS is applicable to NI Act cases that is filed after 1/7. And he will have to issue notice to the proposed accused, hear him, and then proceed to take cognizance and formally array him as an accused. So it is sort of a pre-summoning thing. And if the accused is now, of course, it will lead to some confusion in the sense what would be the scope of inquiry, because naturally the accused will place all his defense before the magistrate. So it may lead to some chaos, but the magistrates will have to devise some methodology, and naturally it will travel right up to the Supreme Court, and the Supreme Court will lay down law on this point.
KSBC Academy host ಯಾರು ಗೌತಮ್ ಜಿ? ಅಲೋ ಟು ಅನ್ಮ್ಯೂಟ್ ಅಂತ ಮಾಡ್ಬೇಕಂತ ಕಾಣಿಸ್ತದೆ. ಅಲ್ಲೊಂದು ಅಲೋ ಟು ಅನ್ಮ್ಯೂಟ್, ಮ್ಯೂಟ್ ಆಲ್ ಇದೆ. ಓಕೆ 1 minute. ಆಸ್ಕ್ ಆಲ್ ಟು ಅನ್ಮ್ಯೂಟ್. ಓಕೆ, ತಾವು ಅನ್ಮ್ಯೂಟ್ ಮಾಡ್ಕೊಂಡು ಪ್ರಶ್ನೆಗಳು ಕೇಳ್ಬೋದು. ಇವಾಗ ಅವಕಾಶವನ್ನ ಮಾಡ್ಕೊಡಲಾಗಿದೆ. ಯು ಕ್ಯಾನ್ ಅನ್ಮ್ಯೂಟ್ ಅಂಡ್ ಆಸ್ಕ್ ದ ಕ್ವೆಶ್ಚನ್.
ಹಲೋ ಸರ್.
ಹಲೋ.
ನಮ್ಮ ಪೆಂಡಿಂಗ್ ಇರೋ ಮ್ಯಾಟ್ರಿಕ್ ಬಗ್ಗೆ ಕೇಳ್ಬೇಡ್ರಿ. ರಮೇಶ್ ಚಂದ್ರ ಇದಾರೆ ಇಲ್ಲಿ.
ತೋರ್ತಾ ಇದ್ದೆ, ಚೆನ್ನಾಗಿತ್ತು.
ಅದು ಮೆಟಿಕ್ಯುಲಸ್ ಪ್ರಿಪರೇಷನ್ ವಾಸ್ ಪ್ರಶ್ನೆಗಳನ್ನ ತಾವು ಕೇಳ್ಬೋದು ಅನ್ಮ್ಯೂಟ್ ಮಾಡ್ಕೊಂಡು. ಇಲ್ಲ ಅಂತ ಹೇಳಿದ್ರೆ ಹೆಂಗಿದ್ರು ರೆಕಾರ್ಡ್ ಮಾಡಿದ್ವಿ ಇದನ್ನ ತಾವು ಇನ್ನೊಮ್ಮೆ ಓದಿ ಇನ್ನೊಮ್ಮೆ ಕೇಳಿಸ್ಕೊಂಡು ತಾವು ಪ್ರಶ್ನೆಗಳೇನಾದ್ರು ಇದ್ರೆ ಕೇಳ್ಬೋದು. ಆಮೇಲೆ ಬೇಕಾ ಮೂರ್ತಿ ನಾಯಕ್ ಅವ್ರು ನಿಮ್ಗೆ ಸಿಕ್ಕಿದಾಗ. ಗೌತಮ್ ಜಿ, ವೋಟ್ ಆಫ್ ಥ್ಯಾಂಕ್ಸ್ ಹೇಳ್ತೀರಾ?
Yeah, please. At the outset, I would like to extend my gratitude and thanks for Mr. Murthy Naik for taking out his time in spite of his busy schedule and giving in a nutshell the overall procedure, criminal procedure. It is very difficult. Someone has sent a message that it will take minimum 4 or 5 days, but you have completed in a nutshell. Those who are practicing on the criminal side, they have understood what it is, and especially these 5 case laws which you have mentioned. please put it on this thing and we will publish it so that it will be beneficial for all the junior advocates. And with these words, I would like to thank Mr. Basuraj and all the audience, advocates, both senior, junior advocates, and especially Mr. Basuraj for organizing this Belaku program, because he is the main brainchild behind this. And once again, I thank you on behalf of
Word from
KSBC
Mr.
Law
Ravi
Academy
Naik, sir.
and KSBC.
Ravin?
I
I,
want to thank
I, I thank,
Basuraj, I thank
yes,
Murthy
Mr.
Naik
For
and all
the
the
audience,
participants.
for the kind attention of the audience, worthy son of a worthy father, Mr. Ravi Naik, sir, is the son of Mr. B.G. Naik. He's a dedicated senior advocate. He also, for quite a time, he was a judge of the High Court. So, one word of appreciation to Mr. Naik.
Murthy Naik's speech was illuminating. It was a guidance to the juniors, and I
Hello.
thank him for having delivered the speech. In addition to the same, I thank the organizer Basuraj and also the participants who have participated in this program.
Sir, excuse me. Hello. Where is the recording available? Hello.
Hello.
ಕೇಳಿ
ರಿಕಾರ್ಡಿಂಗ್ ಲಭ್ಯ ಆಗುತ್ತೆ ಅಂತ ಹೇಳಿದ್ರಿ. ರಿಕಾರ್ಡಿಂಗ್ ಎಲ್ಲಿ ಸಿಗ್ಬೋದು?
KSBC Law Academy ಇದ್ರಲ್ಲಿ ಸಿಗುತ್ತೆ, ಯೂಟ್ಯೂಬ್ ಅಲ್ಲಿ. KSBC Law Academy
ನೀವು ಯೂಟ್ಯೂಬ್ ಹೋಗಿ KSBC Law Academy ಅಂತ ಹೇಳಿದ್ರೆ ಎಲ್ಲ ಉಪನ್ಯಾಸಗಳು ತಮಗೆ ಸಿಗ್ತವೆ. ಎಲ್ಲ ಉಪನ್ಯಾಸಗಳು ಕೂಡ ತಮಗೆ ಸಿಗ್ತವೆ.
ವೆರಿ ಕೈಂಡ್
and this will be uploaded tomorrow.
ವಾಟ್ಸ್ಆಪ್ ಗ್ರೂಪ್ ಅಂದ್ರೆ ವಾಟ್ಸ್ಆಪ್ ಗ್ರೂಪ್ ಯಾವ್ದು ಗೊತ್ತಿಲ್ಲ ನನಗೆ. ವಾಟ್ಸ್ಆಪ್ ಗ್ರೂಪ್. ಹಲೋ.
ವಾಟ್ಸ್ಆಪ್ ಗ್ರೂಪ್ ಬೇಡ, ಹೋಗ್ಬಿಟ್ಟು ಸ್ಟ್ರೈಟ್ ಅವೇ ಯೂಟ್ಯೂಬ್ ಹೋಗಿ KSBC Law Academy ಅಂತ ಹೊಡೆದ್ಬಿಡ್ರಿ, ಸಾಕು ಅಷ್ಟೇ.
ಸರಿ ಸರ್, ಥ್ಯಾಂಕ್ ಯು. ವೆರಿ ಕೈಂಡ್ ಆಫ್ ಥ್ಯಾಂಕ್ ಯು.
Okay, thank you one and all. Let us
Thank you, sir.
conclude. Thank you very much.
Thanks, Lord. Thank you, Naik.
Right,
Thank
sir.
you.
Namaskara.
Namaskara.
ಥ್ಯಾಂಕ್ ಯು ಮೂರ್ತಿ ಅವರೇ, ಥ್ಯಾಂಕ್ ಯು.
Okay.
Thank you.